Welcome. I am Lori Critt-Martin, a certified family law specialist and a former vice chair of the BHBA litigation section. Today, you're going to be hearing about gaining and maintaining jurors' trust. I'm delighted to introduce our speaker, Alexa Hiley. Alexa Hiley is a jury consultant at IMS who assists top litigators by providing insight into how juror attitudes, opinions, and beliefs affect case outcomes, bringing a research-driven perspective by her doctoral work in experimental psychology and law at SUNY Graduate Center. Her research interests include decision-making, attorney decision-making, racial bias in jury credibility assessments, and confirmation bias in expert testimony, work that is recognized by the National Science Foundation's Research Improvement Grant and published in journals such as Law and Human Behavior and the Journal of Forensic Sciences. Alexa holds a BA from Bates College and an MA in psychology from SUNY GC and has built her consulting expertise through experience in state and federal criminal cases, prior work with a California-based litigation consulting firm, and a research role at the BIDMC Transplant Institute. And now let's get started.
Hi, everyone. Thank you for being here. My name is Alexa Hiley. I am a jury consultant at IMS Legal Strategies. And as for the title says, I'm here to talk about gaining and maintaining jurors' trust and how to increase credibility. So I'm going to go ahead and share my screen. That does not seem to have worked. There we go. All right, so what I'm going to be talking about today are strategies to gain and maintain jurors' trust and increase your own perceived credibility with jurors at trial. So I'm going to start briefly by talking a little bit about how communication works, sort of at its most basic level, some of the main problems that we confront when we're looking at how to communicate effectively with jurors in a way that maximizes our credibility. And then I'll focus on some content and sort of more delivery, subset of delivery type pieces, and then I'll get into some of the more stylistic credibility builders and credibility killers. I'm happy to take questions sort of throughout as they come up. I also have reserved some time at the end to get into some questions as we usually end the program. But starting first with how the basics of how communication works. So I'm sure I don't have to tell you all that one of the biggest issues that we face in litigation is the problem of the lay juror. So in other words, we have a relatively random assortment of jury eligibles from the general population who we then bring into the courtroom and we task with making really important, impactful decisions about issues that they really don't know anything about. And if you think about it, everyone else involved in the process went through years of schooling and training and professional development to develop the understanding necessary to operate within the justice system. Jurors, on their hand, are walking in more or less as blank slates. They tend not to know anything, not only about the law itself, but they really don't know anything generally about the subject matter at hand in a particular lawsuit. And then they are essentially put into this position where they are the primary triers of fact. They have to determine which side is going to prevail. And what we're doing there is we are asking them to make critical evaluations of two very competing messages and asking them to determine which is the most valid of the messages. And in order to do that effectively, they need both motivation and the ability. So when we're asking someone to make a critical judgment, any sort of evaluation, the two necessary components are motivation and ability, which I abbreviate as essentially you need a will and you need a way. Motivation tends to be relatively malleable, so there are techniques that you can deploy to make people more or less engaged or motivated in interpreting your message. But we are, unfortunately, somewhat stuck with the amount of ability that any individual juror is bringing into the courtroom with them. There's only so much work we can do to educate them on, particularly on complex, highly technical issues that are involved in a lawsuit. With this in mind, we need to be very realistic in our understanding of how that lack of ability tends to change the strategies that jurors rely on in their evaluations. So specifically, if they don't have the ability to make a studied critical evaluation of the content, the validity of a message, they need to rely on what are called peripheral cues. And that means they're looking at not just what is being said, but they're actually looking at how it's being said. They're looking at the messenger themselves, and specifically, they're looking at the perceived credibility of the messenger. So if you're not able to evaluate the credibility of the message itself, you often look to, okay, how credible does the person delivering the message seem to me? And this is where it becomes so critical as the attorney who's delivering the message that you establish yourself as a credible, believable source of information early on, because that is going to make jurors in turn see your case as more credible. And one of the most important aspects of credibility is actually comprehension. We find things more credible when we are better able to comprehend them. And you can think of it as using your case to build a narrative framework. So you want essentially to build a scaffold or the outline of a house, frame a house, and then let your jurors essentially just do the final touches of decorating. You don't want to hand your jurors a bunch of raw materials in the form of evidence, of testimony, of arguments that aren't tied together. You don't want to ask them to build the house, because what you're going to get is going to be a leaky, falling down, holes in the roof kind of mess. What you want to do is frame the walls, put the roof on yourself, and then let them put the finishing touches. And the way you do this is by building a narrative framework, or essentially presenting your case as a story, because fundamentally at the end of the day, litigation is a storytelling competition, and whichever party is telling the most compelling, easily understandable story to a jury tends to prevail. And this is because if you create the narrative framework, you're providing what's called global coherence. In other words, you're giving them the bird's eye, big picture view. And this is particularly important to establish in your opening statement, where you are giving them your orientation. And you can think of it as the guidelines or the outline through which they're going to interpret everything else that they hear over the rest of the case. And specifically, by building this framework for them, you are telling them how to make connections between what they've already heard and what they have yet to hear. And the more connections you can build between different pieces of evidence, the better their recall is going to be later on. And the main takeaway point here, which quite frankly, I'm sure I don't have to really tell most of you, it's that oftentimes in litigation, we find that the winner is not necessarily the person who has the best legal argument. I've lost track of the number of times I've had an attorney say, I could have sworn that I had a much stronger legal argument than the opposing counsel. So I'm not sure why all of a sudden they've returned a verdict against me or against my client. And what it boils down to is that the other side had a better story for the jurors to latch on to. If we're looking at this on a psychological level, this phenomenon is essentially tied to something that's known as processing fluency, which basically means the more easily we process something, the more it strikes us as being credible. So in other words, arguments that are easy for us to understand have that gut check feeling of feeling more right or more correct. If something feels intuitively correct, if it has a lot of what's called face validity, it seems more credible. And one of the easiest ways to increase processing fluency is to make sure that you absolutely nail down organization and coherence. And it's important to note that developing your organization and laying out the structure of your case starts early on. Honestly, it even starts before opening statement. It starts during voir dire. But particularly when you get into your opening statement, you want to make sure that right out of the gate, you're calling attention to the central idea of your case, your initial themes. So don't start with a long-winded spiel of thanking people or introducing people. You've already done that during voir dire. And you can think of jurors essentially having a countdown or a stopwatch timer on their attention span. And you have a very limited window of time to get in there, grab their attention, and explain to them how you're going to lay out your case. Your organization should then flow throughout your case. And really what you're looking for is you're going to get on any jury 3 to 4, maybe 5 if you're lucky, thorough note takers on a jury. And they should be able to very easily follow the outline of your case through your notes. So openings and closings, they are sort of unique in terms of the specifics of the rhetorical situation that you're in, but they do follow the same general pattern of any good speech. You can think of it. They're still speeches. They should have a structure and an organization that should be easily followed. You should use your introduction to make sure to capture attention, give them a reason to listen, establish your credibility, and preview your main points. Then at the end, you should make sure to revisit each of your main points and provide closure. And the one thing I want to note right here is you never want to make a good point once. You always want to make sure your strongest points, you're making them multiple times because repetition increases recall. Another quick way to present your information in a way that gives you more credibility at face level is to avoid boring your jury. So that means you want to make sure that you are avoiding what I call death by PowerPoint or death by bullet point. Jurors, essentially, if you give them a slide that are a bunch of bullet points that just exactly mimic what you're saying, you have automatically lost their attention. They're not listening to you, they're reading what's on the screen behind you. This is going to, in turn, break your connection with them. It, from your perspective, will generally flatten your delivery because you will then have a tendency to read off the bullet points rather than making your own independent points. And it does, and ultimately weaken your credibility. So you should think of slides not as a script for yourself, but as being a supplementary materials for your audience. And keep in mind that a strong visual, because your slides ultimately should be visuals, does one particular thing well, and that is it highlights a key point. It either simplifies a concept or it directs attention. And you want to pick one. Essentially, it's an anchor for jurors to direct their attention to while they're listening to you. It shouldn't be something that pulls their attention away from you. So in other words, simple goal with your visuals, you talk, the slide supports, it should never be the other way around. So this is an example of what is not a visual aid. And this is essentially just a bullet point. It is going to reiterate exactly what you're already saying. And importantly, it's not doing anything to make your argument more comprehensible to your jurors. If a juror doesn't understand these words as you're saying them verbally, odds are they're not going to have much better understanding when they're reading them at the same time. If you want to make it a visual that is going to help increase your comprehensibility to your jury, you want it to look maybe more something like this, where essentially you're using a different modality of communication. It augments what you're saying rather than competing with it. And this is where oftentimes I get people saying, all right, but then I need my speaker notes for my bullet points. And this is where I sort of say, you can have that in the speaker view of PowerPoint. You can print them out on slides, but you should never be using your own slides as your notes. It's another example of an immersive visual for the, say, dose response assessment, just providing a real punchy visual that augments what you're already saying. It doesn't reiterate it exactly word for word. The other important aspect of credibility, unfortunately, is not just what you're saying and the content, but it's how you say it. It's all these sort of peripheral pieces that jurors focus in on and use that to make determinations about whether you are or are not a credible speaker. So the way I'm going to frame this is I'm going to give some overall points about general things to keep in mind, different modes of delivery. And then I'll get into specifically what I call credibility killers, or the sort of what not to do, and then transition to talking about credibility builders, or techniques and strategies that you do want to use. And I'll flag this now. Those last pieces I'm going to talk about, the credibility killers and builders, those are applicable not just to you as the attorney, but those are pieces you can actually take when you're working on prepping a witness for deposition or for trial, and they're going to be applicable to your witnesses as well. So they're sort of universal ways to build or undercut your own credibility. But I want to start by talking about the three general modes through which you can deliver a speech. You have memorization, manuscripts, and extemporaneous. So I've worked with vanishingly few attorneys who have some sort of, say, formal acting training and therefore have the ability to memorize and then deliver a script in a way that seems natural and off the cuff. Generally, if you don't have formal training and exceptional skill in this area, I strongly, strongly advise that you avoid taking that memorization route because it's incredibly high risk. Really, for most of us, the risk far, far, far outweighs the reward. You run into the likelihood of A, forgetting your script, drawing a blank, and then being unable to get back on track and not knowing where to go from there. Or even if you deliver it word for word perfect, quite frankly, most of us are not very good actors. If acting was easy, we'd all be doing it. And it is very difficult to deliver a memorized script without sounding canned or rehearsed or phony. And one of the things I'll be talking about and mentioning a couple times for the rest of this presentation is that jurors generally have a very sharp radar for when things seems false. And there is almost no quicker way to make yourself seem off-putting to a jury than to come across as phony or as disingenuous or overly rehearsed. The other, so you have then the manuscript version, which is almost worse than memorization. So that's when you actually have a printed out script and you're actually looking at it in your hand. I cannot ever think of a situation where I would recommend doing that because the temptation is always to, have your papers clutched in your hand, have it up to your face, looking down on it as you're reading. You might get tripped up as you're trying to follow the script while reading. So I strongly recommend avoiding the manuscript approach. There's more. Some people, again, can pull it off, if you're really good at, say, cold reading. But again, I really strongly recommend not relying on that either. What I do recommend then is this third category, extemporaneous speaking. So this is where you start by writing out a script. You might memorize particular sound bites or particular themes that you want to rely on. And just a note, a theme, when I talk about a theme, what I mean is a short, intentionally oversimplified concept that jurors can use to help understand key aspects of your case. So you can essentially think of it as a headline or a tagline for some important aspect of your case. Those you can memorize so you know how to deploy them smoothly and easily throughout your argument or your opening statement. But you want to avoid overly scripting. So you want to have bullet points. So you start with script, reduce it to bullet points. And the bullet points help you stay on track, stay organized, make sure you're not overlooking anything critical. But they don't give you quite as much danger of tipping into that territory of sounding like you're an actor on stage, like you're, in an amateur play delivering a monologue for an audition. And they help you sound a little bit more dynamic, and it helps you connect a little bit more with your audience. You're able to make eye contact, interact with them a little bit more as a speaker, because you're not staring down at your notes or you're not locked in trying to recycle word for word the script that you've memorized. Beyond the mode of how you're delivering your speech, you also want to be mindful of the impact of your message, or particularly what are the ways in which jurors are getting information from you while you're delivering your message. So only a relatively small portion of the information that jurors are going to take away is that verbal portion. So the words that you are saying, how you look and how you sound while you're communicating has just as much as, if not more, of an impact on how your message is received. And it's important to keep in mind that jurors, as part of sort of the lay juror problem for a lot of them, their only exposure to what an attorney, quote unquote, should look like or should sound like comes from what they've seen on movies and in television. So that means they're walking in with a certain amount of expectation for how a courtroom is going to look, how an attorney is going to present themselves, how they are going to deliver their case. And being aware of those expectations can be very helpful, because if you are to some degree aligned with what they expect, that can actually make you seem more persuasive, because they sort of have the stereotype of this is what an attorney is. And if you can fulfill that, you are going to come across as more credible than if you are violating their expectations. For example, by sounding incredibly stiff and uncomfortable when you're speaking. And so I'm going to talk about later on the specifics of being more persuasive in terms of how you modulate your vocal delivery, the visual impact that you're making. But I want to emphasize the multiple modality aspect of communication, because I want to point out how important it is that you practice in all of the modalities. So a lot of times the temptation is to practice by writing out your speech, reading through it, rehearsing it, in your mind, rehearsing it subvocally. But that's essentially the equivalent of if you say if you're a golfer or a baseball player, it's like or a tennis player, it's like visualizing your swing, but never actually taking practice swings. Or another example would be it's like imagining dance moves, and that's practice, as opposed to actually getting out, moving your body, going through the steps. And I picked the dancing example and the example of going through the steps purposefully, because you actually do want to go through the literal steps of presenting your argument. You want to rehearse how you're going to stand, how you're going to move. If there's particular gestures that you want to use to emphasize certain points. And I oftentimes, when I make these recommendations, get some pushback in terms of the amount of time that ends up taking to carve out dedicated time to have a good, effective practice sessions. I know it's very tempting, especially as you're in the run up to trial and you're in that sort of frantic last preparations phase. It's very tempting just to, on the plane, on the commute, read through a script and consider that practice. I'm going to tell you now, it is 100% worth every minute that you can carve out to actually practice. You can get a practice audience to stand in front of and deliver even portions of your argument, your opening, your closing. That can be so effective, and it gives you much better, more useful practice than just rehearsing. One thing I recommend, if at all possible, is if you practice in front of a critical audience that provides what I sort of refer to as like friendly fire. So a spouse, a partner, if you have a critical teenager at home, they can be a great audience in terms of making sure that you're pitching your case at a level that is comprehensible by, sort of your average adolescent is, quite frankly, about the level of comprehension you want to be aiming for, given the breadth and diversity of the potential jury. But also you want someone who's going to give you unvarnished criticism and who isn't going to be afraid to say, the content's great, but your hair is sticking up weirdly in the back, or your content is great, but you're doing this really distracting thing with your hands when you talk about this one section. Getting that kind of harsh but necessary breakdown of not just what you're saying, but how you're saying it and how you look while you're saying it is absolutely valuable. So we're talking about disciplined execution as a speaker. A couple things you want to keep in mind. So you want to first build trustworthiness, and signals for trustworthiness that jurors look for. So these are things like strong eye contact. So don't stare your jury down. Don't be making 10 seconds of sustained eye contact with each juror in turn as you're going through, but make sure you're looking at your audience as you speak. You can oftentimes, if you pick a spot just above sort of the heads of the last row of the jury, that gives the illusion that you're making eye contact with the entire jury sort of at once. But make sure you're moving your gaze around. Make sure, you're facing sort of all portions of the jury box. Turn your head so you're addressing different parts of the crowd, particularly during voir dire when they might be scattered throughout the courtroom. Make sure that you are using your gaze to draw your entire audience in, no matter where they're sitting. You also want to make sure you're projecting your voice. So make sure that they can hear you without sounding strained or like you're shouting. And you can use sort of active listening or affirmative head nods as you're speaking. Note, use this sparingly. You don't want to be bobbing your head up and down constantly as you're talking, because that gets very distracting. But you are using your body language to project affirmativeness and warmth and confidence. Next piece is similarity. And so you want to make sure, for example, if you're using examples in your cases or in your voir dire or anything like that, you want to make sure you're using examples that are going to ring bells with jurors. So easy example, if you're in Vegas as your venue, that's a really easy one. If you have, a commercial case, you have a million different examples, gambling, casino-based examples of the idea of risk versus reward, or odds, or anything like that. And that's going to land with that audience. So, know your audience, do some research, tailor it to your specific venue. The other thing I want to make sure that I leave you with is avoiding creating what's known as identity threat. So identity threat basically happens when someone suggests to you that they either associate you with a group of society that you don't appreciate or approve of, or they suggest that you don't belong to the in-group in some way. And people have, from social science research, we know that people have very strong negative reactions to being confronted with identity threats. Not just on an emotional level, there's actually physiological reactions that happen. So we see increase in blood pressure, we see a rise in stress hormones when people feel they've been singled out as being a member of the out group. So an example of what this might look like in the context of a courtroom is completely unintentionally. You might be trying to put the jurors at ease and make sure they don't feel bad or uneducated or dumb for not understanding a particularly technical, say, IP law concept. And you might say, you didn't go to law school, so you don't know how the finer points of this, but that's totally fine. Let me explain it to you. That first piece, you didn't go to law school, you're unintentionally drawing this very clear line between me, the attorney who is educated and wise and the expert, and you, the uneducated masses, and you're separating you from them. Or, for example, if you're talking about a case where there's, dealing with some sort of loss or injury to a child, those of you who don't have kids might not understand how a parent feels seeing a child experience this. Basically, anything that stakes out potentially some portion of the jury or the entire jury as not belonging to a group is going to put their hackles up and immediately put them on guard. Next piece is dynamism. So we want to make sure that we are dynamic speakers. The more engaging you are, the more credible you're going to seem. So that is, you want to make sure that you are varying the pitch, rate, volume, intonation of your speech. You want to make sure you're using pauses deliberately. And we'll get into the specifics of what you do and do not want to do in terms of your pitch and intonation. You want to make sure you're keeping an eye on your facial expressions. So sort of knowing what your own resting face looks like can be very helpful, particularly for when you're not speaking. Because the thing you have to keep in mind is jurors are scrutinizing you for clues to your credibility, not just when you're up in front of them talking, but the entire time you're in the courtroom. From the moment you walk into the courtroom, from the moment they see you in the parking lot the morning before court, they are always watching you and always looking to see if that mask is going to slip. So you want to make sure you're mindful of what your face is doing at all times, what gestures you're using. You should, if you're going to use gestures, if you're going to use body language, make sure you're doing it deliberately and with purpose. Likability is one of those big sticky issues that can be sort of controversial, but you do want to a degree try to come across as likable without forcing it. So some jurors are just not going to like you no matter what. It might be something about you personally. Some jurors just don't like lawyers. Most jurors are not thrilled to be in court, so they're sort of predisposed to not finding you particularly likable. To the degree possible, you want to combat that. So, even if you're not coming across as likable, you're not coming across as unlikable. So that again gets back to eye contact, a polite, sort of neutral social smile where appropriate. So not a big toothy grin like we might have in a more social setting, but just sort of a polite neutral, positive neutral, as opposed to full flat mouth, complete neutral. And then also being mindful of your body position in relation to your audience. So making sure that you're cheating towards the jury a little bit when you're sitting or standing so that you're not coming across as being closed off. It's a classic. Avoid crossing your arms to put a barrier between yourself and the jury. Try not to hold folders or papers or binders between yourself and the jury in a way that looks like you're warding them off. You don't want to literally create a barrier. And then finally, you want to project an image of competence, because competence, above really all these other aspects, is how jurors judge credibility. The more competent you come across, the more credible you are going to seem. So this looks at not just our articulation, but also using vivid, aligned language. And this is a real tricky balance, because you want to make sure that you sound the way they expect a lawyer to sound. That is like an expert, like someone who knows the law inside and out. But you don't want to tip too far over into the range of sprinkling your speech with jargon and technical terminology that they're not going to be able to follow. So the trick is finding ways to make it seem as though you're using niche lawyer talk legal terms without losing their attention. So that might be providing definition for terms, or using concrete examples to illustrate what you mean by different law concepts. I'm going to say right off that, one specific thing to avoid when you're doing this is I strongly recommend not signposting it too much. So for example, don't say, this is a case involving gross negligence, which is just a fancy legal term for. That's an example of going too far, and you're going to essentially make the jurors feel like you are condescending to them and treating them as stupid. So you want to find that balance. And again, you want to be concrete and specific with your examples. So don't just give them a definition of a term. Make sure they have a specific example, and ideally an example that ties back to the case at hand. Because again, you always want to be thinking about what is that framework that you've built for them with your case narrative look like, and then how are you telling them how to place each new piece of information that they get. You got to tell them where it goes on the framework. So now I'm going to, for the sort of back half of this, of the time, I'm going to get into some of the more nitty-gritty specifics. So the what to avoid and what to deploy of it. I will caveat this up front with there's very few absolutes. So I will note major exceptions to some of these rules as appropriate. But these are good sort of overall rules of thumb to keep in mind as you're working on rehearsing your delivery. And again, these apply not just to when you're presenting at trial, but these do apply from, during voir dire, anytime you're appearing in front of a jury. So first thing to avoid, probably not going to be any surprise, because this is a topic that gets a lot of attention. And I think a lot of us probably have been counseled about this even before, professional training, going all the way back to high school, to elementary school, people telling you not to say like, not to say But the important thing to keep in mind about vocal fillers is they do, in everyday conversation, serve a very important purpose. And unless they're used excessively, we tend to not really to notice them in everyday conversation. They are often used to stake out conversational territory or to indicate that a response is being formulated or that we're being thoughtful about when we're speaking. So, for example, one common use of a vocal filler in everyday conversation is to indicate I need a moment to think of what I'm going to say next, but I am not ceding the conversational floor here. So I am using to indicate that I still want to hold the floor, that I have something loading that I'm going to say. Or similarly, but alternatively, if someone asks you a question, you might need a moment to come up with an answer, but you don't want them to think you are just staring at them wordlessly. You want to make sure that they know I'm contemplating what you're asking me and I'm actively working on formulating a response. You can also use it to imply that you're not sounding overly emphatic, to sort of soften what you're saying to come across as being a little bit less aggressive. They have a real purpose in everyday conversation. However, in the context of a courtroom, in a legal setting, in really any professional setting, it can be very easily misread. Specifically, a juror who hears you start a sentence with, they're not hearing thoughtfulness. They're not hearing deliberation. What they're hearing is a lack of confidence and a lack of conviction in what you're saying. And this is one of those things where I'm going to say, oh, it's an easy fix. Just stop using filler words. Replace them with silence. That's because a short pause in the middle of a sentence in a context where you're public speaking actually reads as having a lot of control and confidence and competence. But it is really hard to put into practice. So one of the things I suggest doing, and this is something I talk about all the time when I'm doing witness preparation, is I give them homework. I say, as you're going around daily conversation, start keeping tabs on yourself. Start to learn what are your particular vocal fillers that you tend to fall back on in everyday conversation, because everyone has a different set that they rely on. And then you're going to enter this fun phase where you're just painfully aware of your use of vocal fillers, but powerless to stop it. And that takes about a week until you start moving into that phase and you can actually start purposefully turning them on and off. And you can say, all right, in this setting, I am going to start making my speech process a little bit more of an online process, and I'm going to consciously strip the vocal fillers from my speech. But it takes a lot of practice, and my recommendation is not to have your first attempt at it be in front of a jury. This is something you start practicing every day. Just I'm in a conversation with my family for the next hour. I am deliberately going to avoid using and or I am not going to say like. And getting comfortable with doing that in a lower stakes situation. This is also another area where it can be great to recruit a helpful but brutally honest friend or family member to let them know, hey, I'm working on not using this particular vocal filler. Can you help me keep an eye on that? The next sort of speech pattern you want to avoid are what are called qualifiers. So these are things along the lines of sort of, kind of, I think, maybe, it seems. All of these may feel very conversational, but actually what they end up doing is undermining your credibility. And because what happens is when you use these qualifiers, you're injecting doubt into the minds of the jurors right at the moment you're actually trying to inject certainty and come across as being persuasive. And what jurors want when they're listening to legal arguments is clarity and conviction. And overuse of qualifiers just ends up diluting both of those things. They can take a really well-supported, well-reasoned argument and make it sound incredibly tentative. And it makes it come across as though you're hedging your bets as opposed to standing firmly behind the point you're trying to make. And the issue with qualifiers is that, again, as with vocal fillers, they do serve a purpose. Oftentimes they can be used to make us try to sound measured, fair, to avoid overstating something. or tipping over the line and pushing something too far. And again, in everyday conversation, it reads as being thoughtful and deliberate and putting care into precision of speech. But in the courtroom setting, it just comes across as you are uncertain of what you're saying. And again, it gets back to that lay juror problem. Juries don't reward careful, precise phrasing filled with qualifiers and nuance. What they're really looking for is, do you sound like you have a strong case that you believe in? And this is something I hear a lot in feedback from both mock juries in mock trials, but also when I do post-trial interviews with real jurors. This idea of, did the attorney sound like they believed what they were saying? And I've never heard a juror say, this lawyer didn't sound like they believed their own argument, but it was still a really good argument, so I was convinced. They're taking the lead from you. If you sound like you have conviction in what you're saying, they are much more likely in turn to have conviction as well. Similarly, you want to avoid hedging, particularly for attorneys. So this is actually a bigger issue for when I'm talking to attorneys than when I'm talking to witnesses, because again, there's an expectation from jurors that attorneys are certain of everything that they're saying. And again, it's a problem because hedging is often used for very good strategic reasons, and there's an instinct to use it to sort of provide yourself some wiggle room, some cover. So something like, oh, the contract was probably intended to cover this conversation, or it seems like the company was aware of this situation. Again, as with qualifiers, what you're doing is injecting doubt into the juror's mind. And then what the juror hears is, well, maybe they weren't aware of the situation, or maybe the contract wasn't actually intended to cover that situation. So the takeaway here is that your goal is not to sound aggressive or cocky or overly confident, but it's to sound like you are aligned with the strengths of your case and that you believe full-heartedly what you are telling the jury. In terms of the more, again, stylistic piece of your delivery, I'd say probably the number one issue I deal with here is monotone delivery. And this is particularly an issue in relatively dry areas of legal practice. So for example, a monotone delivery of a complex case involving insurance coverage or the intricacies of a particular contract. It's very easy to lose jurors just at baseline, given the content. If on top of that you have a very monotone delivery, they are immediately checking out. And when the energy drops, then you have the attention that drops. And when they stop paying attention, they stop thinking you as credible. Because again, the more engaged they are, the more motivated they are, the more they're paying attention, the more you are going to seem like a credible speaker. And again, jurors generally don't separate delivery from substance when they're evaluating a message, particularly if it's a message that they don't have the ability to critically evaluate. So if you're delivering some information in a very flat, measured, even-keeled, but ultimately monotone way, it's going to strike jurors as being less important or potentially even less true. And the tricky issue that I run into sometimes, and some of the pushback I get, is this idea that, well, we want to sound controlled or measured or professional, and we don't want to sound like we're letting emotions run amok. And there's a balance between being monotone and being theatrical. Certainly, you don't want to be having your intonation going all over the place, up and down the scale, running wild. But you do want to make sure that you're offering some variation, that you think of it this way. If you don't sound interested in what you're saying, why is the jury going to be interested in what you're saying? And again, so everything you are doing when you're speaking to a jury should be designed to help them stay locked in. and help them pay attention. And you can use shifts in intonation and shifts in your delivery to signal when something is important or when something is surprising. Because again, juries are taking their cues from you. So if you're highlighting, a surprising fact that you're revealing in your case, you should mark that with a shift in your tone, in your delivery, in your volume, within reason. And the idea is you are essentially, with the way you are delivering what you are saying, you are telling the jury how they should be reacting. And if you are just delivering everything, a wall of information in a monotone, absolutely nothing about your case stands out. And if you don't have anything in your case that stands out, then the jury doesn't have anything to hold on to, and they have nothing they're going to take back with them into the deliberation room. In addition to your vocal delivery, you also want to be paying attention to your posture. So at the risk of sounding like everybody's nagging parent, you want to stand up straight. You don't want to slouch. If there's a podium or a lectern in front of you, make sure you're not gripping it and leaning forward, hunched. I think we all have a tendency to fold into what I've heard referred to as that corporate shrimp shape with, sort of our spine rounded forward, the shoulders rounded forward. But you want to make sure you're really actively maintaining your shoulders rolled back, your spine straight, because again, that is the mental picture that jurors are going to have of you. And they might not consciously be thinking, oh, that person is slouching, but they are making sort of a rapid head to toe intuitive judgment about what impression is this person giving me. And adjusting your posture so that you're standing up straight and not slouching is going to be a really quick way to increase your visual credibility. Similarly, you really don't want to be fidgeting. If you are someone who knows that you are a fidgety person, so if you're someone who, if there's a pen or a paper clip or a piece of paper or anything within reach, you're going to be picking it up and rolling around and tapping and fidgeting it, make sure there's nothing available for you to grab. Because what might be a completely innocuous venting of some excess energy comes across to a jury who, again, is scrutinizing your every single move, you're going to look shifty or nervous or uncomfortable or think that it's a tell of some kind. Same goes for if you're sitting at the table, at counsel table while you're speaking, and your leg is going like crazy under the table, or your foot is jiggling. All of those things you want to make sure that you're aware of and not doing, because it creates this overall picture of nervous energy. And then the juror is going to be wondering, what's going on that's making this person nervous? The last thing to avoid I'm going to talk about is displays of negative emotion. And I'm going to caveat this one particularly because there are instances in which well-deployed displays of emotion can be incredibly effective in the right case, in the right context. However, inappropriately deployed displays of negative emotion risk giving the appearance of losing control. So particularly with anger, this can really quickly undercut your perceived credibility because juries are going to see it as something about the case, something about the other party, the witness you're interacting with, as them getting under your skin. You might come across as bullying a witness, even if they're being really frustrating and obstructionist. You might come across as bullying. If you are displaying outrage on behalf of your client, it can come across as being performative or manipulative. And I unfortunately do have to mention that there are some folks who just get a little bit more latitude here than others. So for example, with displays of anger, women tend to be judged particularly harshly and negatively. So if a female attorney shows a display of anger during a case, it tends to have a much stronger negative effect on her credibility because it's seen as losing emotional control. Whereas a male attorney, particularly an older male attorney, it actually might be seen more as a display of strength. So that is just an unfortunate thing that we all have to be mindful of is this an appropriate display of negative emotion? Is it deployed in a tactical way? And can I get away? Is the audience going to let me in particular get away with it? All right, so now I want to shift to finishing up talking about what we do want to do. And the first thing I want to talk about is what I call the butter knife principle. And this is the idea that every case has some bad facts that are just irrefutable. You can't run from them. You can't ignore them. You can't do an end run around them. And if you try to do that, really what you're just going to do is make yourself look squirrely to the jury. You're going to make yourself seem dishonest. They're going to see you as shifty, or as sort of a cheerleader. Like, all you're doing is focusing on the positive. So one of the easiest ways to build credibility in the eyes of the jury is by acknowledging bad facts in a way that takes the sting out of it. And this is what I call it the butter knife principle. So it's the idea of you fall on your sword, but if you do it correctly, you blunt it enough that you're falling on a butter knife rather than falling on a sword. So one great way of doing this is by owning up to bad facts as early as possible, ideally before the other party can bring them up. And again, we look into how jurors look to you to respond. So if you are upfront and matter of fact about a bad fact and treat it as not a particularly acknowledge that's not good. So for example, if there's an email or a text that is particularly unflattering to a client, acknowledging that the email is not good, that it indicates a less than ideal attitude, or creates an unflattering appearance of them personally, but not allowing it to be treated like this big explosive revelation. It takes the wind out of the sails of revealing it. And the earlier you can do it, the more time you give a jury to habituate to it, to digest it, to sort of get over the initial shock of seeing it. And it's this sort of paradox of the more you're willing to own up to bad facts, generally speaking, the more the jury is going to find you credible later on when you present better facts. You also want to make sure, again, I probably don't have to tell this to most of you, but just dressing the part, going back to this idea of jurors have expectations about what attorneys look like. I'm going to say there's very few hard and fast rules. So I get questions like, oh, is it true that I shouldn't wear a black suit? Is my case going to live and die on whether or not I wear a pinstripe? Does the color of my tie really matter that much? And my main point for this is really all you want to remember is ideally a jury's not going to remember what you were wearing. Again, in talking to as many jurors as I have, I've never heard a juror comment on an attorney's memorable outfit in a way that was intended to be flattering. So what you want to avoid, first of all, especially in today's climate, nothing that is a political signal or symbol. So nothing that might indicate support for a particular cause or a protest against a particular cause, because generally jurors will not read into the absence of something, but you're always going to have a subset of your jury that will read into the presence of it. So please be very careful with with tie pins, any sort of buttons, messaging, logos, anything like that, for political organizations. Just make sure you're very carefully eyeballing everything to make sure there's nothing that can be read into it. Also, generally, just logos and branding on the whole, nothing that should be recognizable from across the courtroom as being a major brand or a high-end designer. I generally recommend avoiding, for example, a $30,000 watch, because again, odds are most jurors aren't going to recognize that it's that nice a watch. But if they do recognize it, that's going to draw their attention, and it's not going to be in a good way. Avoid noisy jewelry. So jewelry that's going to clack against each other, is going to make noise, particularly if you're going to be mic'd up at any point during the trial. Also, sort of on the opposite end of don't wear anything too memorable or flashy, do not wear the same thing every day to trial. I will never stop being surprised by how often I have to tell people this, that jurors will notice if you're showing up in the same suit and the same shirt and the same tie every day. Even if you're wearing a different white shirt every day, the juror's not going to know that. They're just going to see you showing up every day in the same outfit. So there should be some variation, but not, a different memorably patterned suit every single day. The biggest thing to keep in mind, though, is you just want to pick clothes that you're comfortable in, that you won't need to fuss with or need to adjust. Any sort of self-grooming behavior is a major killer of credibility. So don't wear something new on the first day. Make sure you're comfortable in it all day. Make sure that you test sitting up, standing down, moving around, pointing, full range of motion in your outfit, and that everything works and you're comfortable. This is sort of the corollary to what I said before about emotion. If you're going to use emotion, use it very carefully. And primarily you can use it to create contrasts. So, for example, if you're dealing with a really rude or uncooperative witness and you manage to maintain steely politeness in the face of that, or you have, opposing counsel who's getting really worked up and seems to be bullying your witnesses, or who is shouting and getting angry, the more you can remain even keel in contrast to that, or, if you have a seemingly robotic, remorseless corporate representative on one side, and you are advocating for, an individual who's been injured, if you have a carefully controlled and not overblown display of empathy, that can be very, very useful. Similarly, if you are representing a corporation, if you are representing a defense, strategic displays of empathy can be incredibly effective. So being able to say, what happened to this plaintiff is undeniably a tragedy, and I am not here to tell you otherwise. It is awful that they have had this experience. However, we are not liable for reasons XYZ. And that gets back to that butter knife principle idea of, at a certain point, you can't deny that someone has been harmed or experienced a real damages or a devastating accident of some kind. And it's human, and it humanizes you to acknowledge that, but then also say, however, courts of law are about justice, and justice is not assigning liability where none exists. So this is an area where engaging in jury research can be very helpful in terms of gauging exactly how to deploy emotion, where you can deploy it. Is it going to be effective? Are you going to have some blowback as a result? It's a controlled environment where you can experiment with different ways of deploying emotion as part of your case. The other piece I talk about is what I call the airplane seatmate rule. This is particularly true during voir dire when you're directly interacting with the jury. Oftentimes there is an impulse to be a little bit too friendly, too jocular with juries, and quite frankly, they almost all find it extremely off-putting. They understand that you're not their friends. Again, as I said before, none of them really want to be there for the most part. And what they're looking for you is to be polite and respectful and professional, respectful of their time, appreciative of their service, without tipping over the line and being too fawning, too falsely warm. And so I say, aim for the vibe you'd have if you were making polite small talk with someone in the airplane seat next to you as you're settling down. So, someone, you're going to be in a small contained space with them for a long period of time with no escape. And it's in your best mutual interest to maintain a friendly surface level politeness, but you're not going to come out, disembark that plane with a new best friend, most likely. That's sort of a good rule of thumb to keep in mind when you're thinking about how to pitch yourself when you're interacting with a jury. And then finally, I want to end with what I will acknowledge is essentially the biggest cliche of all, but I can't not leave you with this because it is actually incredibly important. And that is just be yourself. Again, you can be the most polished, practiced, presentable version of yourself, but there's nothing that is going to alienate a jury faster than an attorney that they see as being phony. So I would never, ever advise anyone to try to develop a whole new personality to deploy just at trial. If you're not naturally a very outgoing, bombastic, backslapping kind of, extrovert, you don't have to transform yourself into that at trial. Or if you're not a, someone who's a very dry, detail oriented and by the book rule follower, you don't have to transform yourself into that because you think, oh, that's what a jury expects of an attorney in this type of law. You can bring genuine aspects of your own personality into the courtroom. And the specific examples I use here, for example, you don't want to, if you're going, say, into a smaller town venue, you don't want to try to take on like a fake folksy, aw shucks, I'm just a guy, I'm just a gal manner just because you're in a small town. They're going to know you're not from there. If you have local counsel, great, that's their job. Or similarly, and this is something I've literally told people, I'm never going to tell a California lawyer to wear cowboy boots in Texas. Because again, you want to make sure that you are, whatever you're projecting, that it has some grain of genuine truth. Because otherwise, the jury is going to know immediately that you're projecting something that you're not. And that is going to be the ultimate credibility killer. And that is, I'm going to go ahead and stop sharing, the end of the presentation. So now if we have time, I know we're sort of at the hour, but if there's any questions or anything that came up during, I'm happy to stick around for a little bit longer and answer.
Yeah, so it looks like we had two questions within the Q&A. The first one from Heather Atkinson. What ideas do you have for self-represented parties when presenting evidence before a jury?
Great question. I think the main thing is you want to, again, a lot of it is what applies for everything I've said. I do think there is an expectation that unfortunately you're just going to be held to a slightly higher standard to the extent that jurors are going to understand what it means to be a sort of self-represented party. And you just want to be a little bit more aware of, for example, things like that, the idea of coming across as being a uncritical cheerleader of all times. And so actually, if you're self-representing, you gain more credibility from engaging that butter knife principle because you're not even just saying, oh, this is a bad fact for, my client. This is a bad fact specifically, excuse me, specifically, effectively for me personally. And it's the principle of admitting something that is against your own self-interest, which paradoxically builds your credibility. And the more directly against your personal self-interest it seems to be, the more credibility you get from making that admission. So the main thing would be identify potentially challenging aspects of your case or, challenging pieces of evidence, bad witnesses, anything like that, and make sure that you specifically practice how you're going to incorporate acknowledging and owning up to them into your case. So you're not trying to do it on the fly. And that might be an aspect where you maybe are scripting yourself a little bit more, because the harder something is to think about, to confront, the more you want to err on the side of scripting yourself.
Great, thank you. And it looks like we have another one from Barbara. How applicable is all of this for presenting to a judge or arbitrator rather than a jury, other than acknowledging that the trier of fact does in fact have a law degree?
I know a lot of judges who might take issue with what I'm about to say, but quite frankly, judges are people too, and they are subject to all of the same biases and heuristics and judgments that I outlined as jurors. Like, yes, they have law degrees, but oftentimes they're they don't have experience in a particular area. They have not maybe been actively practicing for a while. A lot of what I was saying, particularly about, how we judge people in terms of not just what they're saying, but how they're saying it, that is a human universal. It is certainly heightened in instances where you lack the ability to critically evaluate an argument, but just because a judge has that ability to some degree doesn't necessarily mean that they are then immune to the influence from these more superficial peripheral cues in a way. So I think my answer to that would be, a judge might be making a more content-based assessment of what you're saying, but they're still also assessing all those other pieces. And that's particularly true if you have an instance where you have a judge making any sort of assessment related to expert testimony, because in that instance, the judge is essentially a layperson. They are being asked to some degree, make judgments about an area of expertise that is not their own. So that is almost more applicable to making sure your experts are maximally credible on the surface when you're dealing with a judge.
So we have one more question. Do you see appellate advocacy as different?
Oh, interesting. I admit right up front that I've never specifically thought about that distinction. I do think in terms of the appellate court, you are looking a little bit more in the weeds in terms of the nuances and the specifics of the content, more so than average. However, I would say that you still have a lot of the issues. So, for example, everything I was saying about the modes of delivery, so being scripted versus reading from a manuscript versus being extemporaneous, all of that is still very applicable in an appellate situation.
It looks like all the questions that we have today. Do you have any other remarks that you'd like to make, Alexa?
No, I think that's about it for me. Just thank you all so much for being here and for having me. I really appreciate the opportunity.
Alrighty, this concludes today's presentation. Thank you so much, Alexa, for joining us for a fantastic presentation today. And thank you so much to our audience. Have a great day, everybody.